Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting with an important update from the Karnataka High Court, which has today dismissed petitions filed by CBI and BJP MLA BP Yatnal, which challenged the state government's decision to withdraw consent for a CBI investigation into corruption allegations against Congress leader and Deputy Chief Minister D.K. Shivakumar. The background of this matter is that in August 2017, the Income Tax Department raided various premises of Shivakumar in New Delhi and elsewhere, seizing around 8 crores. Following this, a case was filed against him under the Income Tax Act. The ED also opened a case leading to his arrest in 2019. Further, ED issued a letter under Prevention of Money Laundering Act, after which the then Karnataka government sanctioned the case and referred it to CBI for investigation. Earlier, the High Court had dismissed Shivakumar's plea to quash the CBI disproportionate assets case against him under Prevention of Corruption Act, and the Supreme Court also upheld this decision. However, after the Congress party took over the Karnataka government in May 2023, it withdrew its consent for this CBI probe in November 2023. So the CBI and BJP MLA Yatnal approached the Supreme Court challenging the state government's decision of withdrawing the consent. CBI contended that once consent is given by the state government, it cannot be withdrawn, and in any case, it cannot be withdrawn with retrospective effect. Senior advocate Kapil Sibal, on the other hand, appearing for the state government, had questioned the maintainability of the petitions. Delivering the judgment today, a division bench of Justice K. Somashekar and Justice Umesh M. Adiga has dismissed the petitions filed by CBI and the BJP MLA. For more details on this, you can visit livelaw.in. A division bench of the Bombay High Court, comprising Chief Justice Devendra Kumar Upadhyay and Justice Amit Borkar, was today hearing a PIL filed by RTI activist Anil Galgali, challenging the state government's decision to lower the cost of police protection during IPL matches and apply this reduction retrospectively. The petitioner here stated that through a circular issued in June 2023, the state government reduced the security charges of IPL organizers with retrospective effect from 2011. The petitioner contended that the state's decision to waive the arrears was causing a loss to the public exchequer. Noting that the amount owed was 14.8 crores in arrears, the court criticized the Maharashtra government. It said that water charges are repeatedly increased for slum dwellers, yet no charges have been imposed on such organizers. It said that BCCI was the richest cricket body in the world, and it was because of such decisions. The court has directed the Additional Chief Secretary of State Government to file an affidavit disclosing the total arrears of cricket match organizers from 2011 till date and the efforts made by the state to recover these arrears from the organizers. In the next update, the Calcutta High Court has refused to stay release of the movie titled The Diary of West Bengal. The movie depicts events around the 1971 Bangladesh Liberation War. The petitioners had sought to halt its release on the grounds that it made depictions which are communal in nature, and due to the present volatile situation, it would be better to defer its release for the time being. However, a division bench comprising Chief Justice T.S. Sivangnanam and Justice Hirannamay Bhattacharya declined to grant urgent relief on the plea, stating that the courts have repeatedly upheld that in a democratic setup, individuals have the choice to watch a movie if they wish, and if not, they can simply refrain from doing so. And any healthy criticism is welcome. West Bengal, the court said, is a tolerant society. The plea was further listed for further hearing after 3 weeks. The Apex Court has held that New Delhi Municipal Corporation, that is the NDMC, would not be liable for absorption and payment of benefits to excess staff of the school run by Delhi Sikh Gurdwara Management Committee on account of the closure of a school without prior approval of the NDMC. The court said that as per Rule 46 of the Delhi Education Rules, it was incumbent upon the Gurudwara Management Committee to get approval from the municipal corporation before closing the school when it contributes 95% of the fund amount used for the management of the school. The committee's failure to take necessary approval does not shift the responsibility upon the municipal corporation to absorb and provide salary and other benefits of the teaching and non-teaching staff of the school run by the Gurudwara committee. Further, the bench of Justices Hima Kohli and Sandeep Mehta ruled that NDMC must cover the pay, benefits and pensions for school staff due to the illegal closure. However, it can ask the Gurudwara Management Committee to reimburse these costs. The Supreme Court has suggested that the Union of India should incorporate provisions which allow certificates for identity and gender change that are issued under Transgender Persons Protection Act as valid documentation for applying for a PAN card. A bench of Justices Sudhanshu Dhulia and Ehsanuddin Amanullah said this while disposing of an SLP seeking reliefs for members of the LGBT community, especially transgender persons, regarding the application process for PAN card. The court noted that the Union of India has largely agreed with the petitioner's demands in this case, including accepting certificates issued under the Transgender Persons Act 2019 by the district magistrate. The court suggested that the Union of India should also update the rules to make this official and clear. Let me tell you that the income tax rules govern application process for allotment of PAN. The petitioner in this case had sought that the application form for a PAN card be updated to include a third gender option aligning with the categories available on the Aadhaar card. Today, while hearing the plea for transfer of trial in the 2015 Cash for Votes case against Telangana Chief Minister A. Revanth Reddy, the Supreme Court expressed strong disapproval of certain remarks made by him over the court's grant of bail to BRS leader K. Kavitha. When the matter came up today before a bench of Justices B.R. Gawai, P.K. Mishra and K.V. Vishwanathan, it was initially expressed that the court would decline to transfer the trial but appoint an independent special public prosecutor to inspire a sense of confidence. But the bench took note of Reddy's remarks on Kavitha's bail, where he said that it is a fact that BRS worked for the victory of BJP in 2024 Lok Sabha polls. There is also talk that Kavitha got bail because of the deal between BRS and BJP. Addressing senior advocate Mukul Rohtagi for the Telangana government, Justice Gawai remarked that the statement made by the Chief Minister might understandably raise concerns. He emphasized that the court acts based on its own conscience and oath and not influenced by political criticism. Similarly, Justice Vishwanathan commented that a responsible Chief Minister should respect institutions and maintain a proper distance while showing respect. He highlighted that the statement made was inappropriate for someone in such a high office. And lastly, the Delhi High Court has today refused to quash the defamation case filed against Congress MP Shashi Tharoor over his alleged remark against Prime Minister Narendra Modi. In October 2018, Tharoor had claimed that an unnamed RSS leader had allegedly compared Prime Minister Modi to a scorpion sitting on a shivling. He termed it an extraordinarily striking metaphor. BJP leader Rajiv Babbar had then filed a case for defamation against Tharoor, saying that he completely disregarded the sentiments of crores of Shiva devotees and made the statement which hurt the sentiments of all Lord Shiva devotees both in India and outside the country. Justice Anup Kumar Mendirata today dismissed Tharoor's plea challenging the trial court order summoning him in the case as well as the complaint. The court said that no grounds for quashing of the proceedings were made out at this stage and that it will be expedient in the interest of justice that the proceedings be permitted to continue before the trial court. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.